Welcome. We are visiting features and values of our justice system. Now, here, this system is to function through human beings. So, let us first have a concentration upon the litigants themselves. We, as citizens, are equipped with a mind. Essential feature of the mind is innocence. Then, this innocence, when is interacted with the worldly life, then it becomes an ignorance unless and until there is a literacy. So, man is born with a mind, and this state of mind is as of innocence. Now, innocence fulfilled mind may be a fine, may be pure, may be of any transcendental values, but as far as the worldly life is concerned, with respect to it, it is ignorant. So, innocence, in one sense, is a pure substantive value. On the other end, it is a ignorance because it has no knowledge about the worldly setups. For it, literacy is required. Now, what literacy will give? It will give worldly wiseness and it will make conscious alertness. Therefore, our system, as worldly laws system and justice system for the worldly activities, is to be viewed in the context of the literacy. So, unless and until there is a law literacy amongst the citizens who will interact and deal with each other, the system in itself will go eccentric. So, if we have to approach a court, a court of law, and if we are expecting justice as per law, then certainly we have to be conscious about the literacy of the individuals having interacted with each other. It is in this context that today I want that we shall have a glance at the provisions of the Sales Goods Act, Indian Sales Goods Act. This act was originally part of the Indian Contract Act. Subsequently, the provisions of sales of goods were segregated and have become an independent enactment. Therefore, the Sales of Goods Act is essentially a contract. However, it is a specific contract. There being a specific contract, so there are specific provisions. Now, see, the one act with which we are intimately related, concerned, is the Sales of Goods Act. Each one of us is having number of transactions a day. At each every step, we go to the shop, we purchase a thing, we sell a thing. So, sale and purchase of the goods is one activity which is abundantly there in our day to day life. And when we actually enter upon a large number of contracts daily, these contracts of every purchase is going to be a contract, but whether we are that much conscious of it or not, then let us see the sales of goods or purchases from a shop or for running a shop is the activity which is manifesting so much that we have taken it natural that the way we are conducting, the way we are dealing is all lawful. However, there are such large number of diversities features. There is so big and so colorful spectrum of these activities that if we sit and think about them, then we will realize that actually we are at each and every step or working with innocence. We are having our ignorance, and in ignorance we are making legal contracts, and the implications of the same, though are not evident in each and every sale, but it is now marking its presence with much frequency, and that is why there has been a need of Consumer Protection Act. See, the Sales of Goods Act is a small enactment. It is of 65 sections range, and it is organized as 7 chapters. If we want to evaluate ourselves as to how much we are lawful or how much we are conscious about our dealings within the legal framework, then let us visit the provisions of this act. Now, chapter 1 is titled Preliminary Sections. It gives short title, extent, and commencement. Section 2 gives the definitions, and Section 3 gives the applications, the provisions of Act 9 of 1872, is the Contract Act. The provisions of this contract, which are not specifically here in this enactment, are to be borrowed or are to be implied from the other provisions of the Contract Act. Chapter 2 gives a formation of the contract. We have seen that under the Contract Act, we have 2 persons. A gives a proposal, B accepts it, and it becomes an agreement. And the agreements enforceable law become the contracts. There, this frame of formation of the contract is already there. However, here in this act, again, this aspect is being taken up as the sales of goods make such a specific zone that it requires specific attention. As it is requiring specific attention and as it is of much importance for us as we are performing these activities daily in a very large number of frequencies. Therefore, let us be through these provisions of Chapter 2, Formation of the contract of sale. Sale and agreement to sell, formalities of the contract are given in Section 4. Contract of sale, how made, subject matter of the contract is in Section 5. Existing or future goods. These sales cannot be only with respect to the existing things. The things which will come in existence in future, those are also permitted to be made subject matter of the sale. So the things which are not existing at present and which have to come in existence in future, with respect to them, there are natural situations with respect to the with respect to those things actually coming in existence. There may be eventualities in between, there may be many factors in between, maybe natural or man made or of other circumstances, but those things which we are imagining at present will come in existence at a particular point of time in future, but they may not come in future. Therefore, such contracts of sale with respect to the future goods are certainly at different pedestal, and those situations as well are being covered by this act. Section 7 provides that goods perishing before making of the contract. Now, a situation is being given. A and B are imagining that some crop will be sown and there will be a crop and there will be grains and there will be sale of them. They are imagining. However, if when we are imagining that some situation has occurred, that thing will never occur. Maybe a flood, there may be no crop or any like thing. Therefore, the goods perishing before making of the contract is one eventuality which is connected with the contract of section 6. Your section 8 words, goods perishing before sale, but after agreement to sell, what how to be dealt with, how the price is to be ascertained, agreement to sell at valuation, then how evaluation is to be made, what are going to be the conditions, what are going to be the warranties, and how the stipulations with respect to time are to be dealt with, how the conditions and warranties are to be interpreted, when condition to be treated as a warranty, then implied undertakings as to the titles, etc., being sold by A to B, then sale by description, if the description goes wrong and what happens, implied conditions as to the quality or fitness of the things, and the sale by a samples. Now, need for making specific legislative provisions as these are brings us face to face with the reality of our contracts with respect to the sales of the goods. So if one is not conscious, if one is not literate enough, if one is not alert, if one is not worldly wise as well, then he cannot be permitted to take the plea of ignorance or innocence. So, innocence or ignorance as such are not permitted to have the worldly wise dealings. So, these contracts, these dealings demand that we shall have proper literacy, we shall be properly conscious, there should be conscious alertness, there should be worldly wiseness. Now, these features, these values which you are expected, if those are not there in one or the other party, then the eccentricity is bound to occur, which as a result thereof will give enough strain for the judicial system as well as for the citizens themselves. Therefore, to expect a proper justice from the courts of law as per the laws enacted through human agency, then the standard of alertness, standard of illiteracy is impliedly cast upon citizens. In this context, the question arises that what is going to be the role of the state to provide enough resources and enough institutional arrangements so that the citizens are properly literated, the literacy values deserve to be imbibed, deserve to be infused, deserve to be made available, deserve to be availed by this system, by the citizens. It is in this context that let us read again and again the provisions of this enactment and then come to an answer, come to a conclusion as to what steps are needed to be taken so that this area of activities is not providing higher degree of intensity of strains for the systems and for the citizens themselves as well. Now, chapter 3 is enlisting effects of the contracts. Now, see, once contract formation is there as per the provisions of chapter 2, then here in chapter 3 are being enlisted that what are going to be the effects, and see, it is effects or transfer of property as between seller and buyer. Now, sale of goods means what? It is a transfer of the property. Now, goods must be ascertained. So if the goods are not properly ascertained, how it can be said that property stands transformed with respect to the particular goods? When property passes, when intended to pass, what here implied is that one can say that we are having sale today, means we are having an agreement of sale today. However, the ownership will transfer on some particular date. So this is the conscious choice of the parties to sell, to make as per their desire agreement as to the date on which the property will pass. Now, common sense is not to come into play. Law is specific. The specific law and the common sense may not be at the same pedestal. The specific provisions are specific, and common sense has a degree of projections. Projections may not be as real. Therefore, when we are going for a justice in the court of law, then we have to go as per the specific values of law themselves. It is here where, again, the aspect of literacy comes in. The specific goods in a deliverable state, if things are not in a deliverable state, even then law of sales of goods act is not taking it as if the sale is complete and property stands transferred. The specific goods to be put in a deliverable state, there are the implied conditions. Specific goods in a deliverable state, when the seller has to do anything thereto in order to ascertain the price. sale of uncertain goods and appropriation and delivery up to the carrier, goods sent on approval, or the sale or return, the reservation of right of disposal, risk prima facie passes with property. That the moment property in the goods transfers, then the risk to that title, risk to that property also passes along with it. That means if good goods packet A is that its property has transferred to B, then if the goods of packet A are damaged, then it will be the damage for the person in whom the property stands transferred. These provisions are very specific and very, very fine and very, very delicate provisions. With respect to these provisions, we have to be conscious, we have to be alert, and while entering the contracts of sale of goods, then we have to be worldly wise. And by worldly wise means that we are well aware about these provisions and we are firm in our mind that these, as these are, along with their implications, are going to be accepted by us, and there will be no reason for us to deprive the other person with respect to the rights which stand culminated in that person. So, sale by person, not the owner. Here are the situations, very big situations. Many times in reality, it appears presumption comes to be that as if the particular property is owned by a particular person. However, he may not be the owner. Therefore, the sales of such situations have been specifically dealt with. What are the ingredients of such sales? What are the implications of such sales have been specifically legislated here. So the rights of the parties to such contracts are naturally to be determined as per these specific provisions. Ignorance about these provisions is not going to be an excuse. So the ignorance, when is not permitted to be an excuse, then impliedly it means that we have to be literate. Once we are to be literate, then we cannot take the shelter of innocence or ignorance. We have to keep it in our mind that we have to be worldly wise and we have to be consciously alert of the degree of expectations of the specific provisions of law. It is this feature, it is this value of our justice system which deserves to be imbibed fully. Much of the strain upon the citizens is because of this absence of specific knowledge. Many times people try to show grievance on the basis of their self-imposed, self-projected, and self-evolved morality. Morality and the law are absolutely distinct domains. Therefore, the justice system, the justice through the law courts shall be expected only as per the norms of the specific laws and not otherwise. Like that, in chapter 4, the provisions are regarding performance of the contract, and chapter 6 is taking us to the rights of unpaid sellers against the goods. Some rights have been given. A have taken a particular good but has not paid the price. Then some rights are vested that the original owner, the seller, may take possession of those particular goods, etc., etc. So these are the legal norms accepted, legislated, and made enforceable. Therefore, we shall be through these provisions, and let us evaluate ourselves as to how much we are conscious about the specific provisions of law and how much we are keeping ignorance in our mind regarding these provisions. Thank you very much.
Thank you.